Hello, everyone, and welcome to this Pepper podcast. In July of 2017, Pepper Hamilton formalized our cannabis industry group by drawing together attorneys from a variety of practice areas to make a multidisciplinary team. Those practices include attorneys with experience in health sciences, pharmaceuticals, intellectual property protection, and alcohol and food regulations. I'm lucky enough today to be joined by three partners that lead this team: Alva Mather, Dubow and Michael Jones. Alva, let's start with you. In your spare time, you also chair the firm's alcoholic beverage industry practice group, so you are a natural to help spearhead this team. Can you give our listeners a general overview of the state of cannabis nationally at both the federal and state levels?
At the federal level, it's sort of important to understand that cannabis remains a controlled Schedule I drug under the Controlled Substance Act. And what that means is that it's classified by the federal government for legal purposes and prosecution purposes as a drug that has no currently accepted medical use and has a high potential for abuse. However, as most of our listeners would know, over the course of the last decade or so, there has been a tremendous movement at the state level to recognize first the medical use and benefits of marijuana, as well as in certain states the ability for adults to use recreational marijuana or cannabis under certain regulations. So as we sit here today, medical marijuana has been legalized in 29 states across the country, and recreational use has been approved in California, Massachusetts, Nevada, Alaska, Colorado, Oregon, Washington State, and Washington, D.C. There was in Maine a voter approval for recreational use about a year ago. Unfortunately, at least at this state in time, the governor of Maine has decided to veto that bill, leaving the future for recreational use of the recreational use of cannabis in Maine somewhat under question. But an interesting statistic on the recreational side is that particularly with the opening of California as a market, that 20% or more of Americans now live in states where marijuana has been legalized for adult use.
Can you give us some background on the Cole Memo?
Yeah, so the Cole Memo was actually issued in 2013 by James Cole, who was then the acting Deputy Attorney General. And the memorandum is a guidance to federal prosecutors on what the U.S. Department of Justice wants to focus on from a priority standpoint, given the rise of legalized recreational marijuana in certain states. At the most basic level, what the memo looks at is addressing what are the key issues that the federal government is going to use its resources to prosecute. And what it lays out are things that we would recognize as important enforcement priorities, regardless of whether we were talking about marijuana or something else, such as distribution to minors, or prosecuting those who are seeking revenue from criminal enterprises associated with cannabis, as well as concerns about marijuana moving from a state in which it is legal into a state that it is illegal. One of the interesting things about the Cole Memorandum, in addition to setting out those priorities, is that it also provided the regulators in the states that have legalized marijuana important guidance on how they need to structure their laws in order to protect their citizens, because the other aspect of the Cole Memorandum, aside from listing priorities, is that it makes clear that this is all based on an understanding and an assumption that states are going to be spending significant resources to control the possession and sale and growth of medical marijuana or recreational marijuana in their states, such that the federal government does not need to expend its resources. But the federal government is clear that if the states are not creating regulations that have the appropriate level of control and effective regulatory structure, that the federal government reserves the right to step in at that point in time.
Okay, let's turn to a couple of other specific issues. Is CBD oil legal under federal law?
So CBD oil is not legal under federal law. The DEA has been clear that CBD, as well as other derivatives from the cannabis plant, are treated as Schedule I products under the Controlled Substances Act. So that in that regard, the DEA is not changed their position. They did make a note that they might take a different position if it were possible to produce from the cannabis plant an extract that contained only CBD and no other cannabinoids. But generally, most products are not just CBD oil based.
How about under certain state law?
Again, sort of like what we were talking about with general marijuana, certain states have enacted laws that have allowed for the use of CBD oil either independently or as part of their medical marijuana statutes. And generally what you see there is a recognition under those state laws that there are important medical uses for CBD, generally for muscle relaxation, anxiety reduction, and the state laws mostly look at a balance of allowing for CBD oil with certain very low concentrations of THC, which is the intoxicating element of the cannabis plant, will be allowed for certain kinds of conditions such as epilepsy, involuntary muscular issues, or certain cancers.
Now, what are the practical implications for these distinctions?
Well, some of the practical distinctions are particularly on the manufacturing side. If you are either manufacturing a product that contains CBD, or you may be a large retailer that's looking to carry these products, that while they may be legal under a certain state law, if you then transport that product across state lines or advertise it across state lines, you start to run afoul of what we were talking about as one of the priorities in the Cole Memo, which is not having products cross state lines that are legal in one jurisdiction but illegal in another jurisdiction. So you have to be very, very localized, not only in strict marijuana, but also in its derivatives like CBD oil.
Jay, let's turn to you. You are a seasoned member of the firm's white-collar litigation practice and co-chair of the Securities and Financial Services Enforcement Group. So you bring that litigation prevention view to this conversation. What are the banking concerns when running a marijuana business?
The banking system, which is a federal system, whether the bank is a federal registered or chartered bank, or even if it's a state chartered bank, because it has insurance through the FDIC, the FDIC and the federal system have oversight and control. As Alva said earlier, since marijuana and cannabis are still illegal under federal law, there are limitations in the use of the banking system with regard to marijuana-related businesses. As Alva mentioned and referred to the Cole Memo earlier, which was from 2013, in February of 2014, the Department of Justice issued a second marijuana enforcement memorandum, which essentially extended the Cole Memo's treatment of marijuana businesses to financial institutions that provide banking to marijuana businesses. And because marijuana businesses are illegal under federal law, a financial institution could potentially violate criminal anti-money laundering and money transmitting statutes by doing business with such marijuana businesses. The February 2014 DOJ memo, communicate these issues, but said that they would treat as low law enforcement priorities as long as the financial institutions were working within the confines of the state regulation and were continuing to follow adequate risk-based and money laundering procedures. At the same time, in February of 2014, there was complementary guidance issued by the Financial Crimes Enforcement Network, or FinCEN, which is part of the Department of Treasury. And pursuant to those regulations, they provided for ways in which financial institutions could do business with the marijuana industry. If a bank does decide to do business with a marijuana-related business, then they must file what's called a suspicious activity report, or SAR, at least quarterly, with FinCEN for all their marijuana business clients. This creates an added cost to the financial institutions, and as a result, most financial institutions in the country to date still refuse to do business with marijuana-related businesses. The number of banks is growing that will do business with marijuana-related businesses, but it is still a very small number, resulting in many marijuana-related businesses doing all of their business in cash.
Now, what are the banking concerns for a non-marijuana company doing business with marijuana-related companies?
So if the source of the funds to a non-marijuana related business that is doing business with a marijuana related business comes from marijuana, there is a concern or risk that the banks for the non-marijuana related businesses may also not want to do business with those customers, or if they do business would have to file SARs indicating the source of the funds are from an illegal activity. So if it's possible, if you're providing services, ancillary services to a marijuana business, if that marijuana business has other sources of revenues and can trace those other sources of revenues to your company, you may be able to avoid the concerns of banks not wanting to do business with you or charging higher fees because you're a marijuana-related business.
Mike, you ran the team nicely by being the co-vice chair of the firm's intellectual property transactions and rights management practice group. Can cannabis businesses receive any patent protection?
Yes, under current U.S. patent law, companies that are operating in the cannabis industry are permitted to seek patent protection for their innovations. Unlike trademark law, which I think we'll get to in a minute, where there is a prohibition under current U.S. patent law, there's no such prohibition as long as the innovation meets the other requirements for patentability, which include novelty, non-obviousness, and patentable subject matter. The innovation may be protected via patents.
Can cannabis businesses receive federal trademark registrations?
So as I just mentioned, and Alva and Jay both mentioned, under Schedule 1 of the Illegal Drug Act, it's considered a controlled substance, and therefore it is not permitted to be registered as a federal trademark. And the reason for that is because it's illegal under federal law. It's not able to meet the requirement that there be a lawful use in commerce that is necessary to support a federal trademark registration.
Now, can cannabis businesses receive federal copyright protection?
Under current U.S. copyright law, they are able to protect copyrights for works that are original, creative, and fixed in a tangible form of expression. Again, these requirements do not prevent a marijuana business from registering such works.
Well, this is great. We ran out of time, though, but I really appreciate all three of you spending so much time with our listeners today. For our listeners, there's a much longer FAQ client alert that's updated frequently on this topic on Pepper's website that I will link off this podcast in Pepper's Insight Center at www.pepperlaw.com, where this podcast is posted. Also, since this is a new and emerging industry, if you have other questions that were not covered in this podcast or the FAQ, or would like more detailed information about some of these answers, feel free to reach out to any of our speakers directly. Their bios are linked off this podcast as well, where you can find their contact information. Thank you.